Good afternoon, everyone, and welcome to the Delaware Public Service Commission meeting of October 8th, 2019. First item on the agenda is a reading of the meeting minutes of September 12th, 26th public session, and also the executive session. Does any commissioner have any changes, amendments, or comments, or perhaps a constructive motion?
Point of order, Mr. Chair. I think that the meetings for September 12 does not have an executive session. I move that those minutes be adopted by the commission as submitted.
Second the motion.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? And we have Commissioner Drexler has got a conflict in schedule and will not be here today, and she will be noted as not being here today and not voting. Commissioner Gray, you want to follow up?
The next point of order is the minutes for the 26th. I will abstain, so I'll let one other commissioner make that motion.
Okay.
I'll second the motion.
You know we have to
I'll
make,
make the motion.
He said
He can't, he wasn't here. I'll move that we adopt the minutes for the public session of September 26th and also the executive session of September 26th, 2019.
so now I second the motion.
thank you, Commissioner Correa. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed?
I abstain, Mr. Chair, as I was
Abstentions.
not here.
Yes, sir. The consent agenda, does anyone wish to have an item of the consent agenda taken off the consent agenda? Excuse me.
I'll move that we accept the consent agenda as presented.
I second it.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Okay, the first item on the regular agenda, number one, is in the matter of the application of Lewis Board of Public Works for a certificate of public convenience and necessity to provide water services. So would the parties kindly step forward and take a place at the table? And at the appropriate time, we'll proceed. This is the application of the board, so I guess would the attorney for the board introduce himself and kick this matter off?
Good afternoon, Mr. Chairman, members of the Commission. Michael Hoffman of Terrabicos Grasso, attorney for the Lewis Board of Public Works.
Would you like to give an introduction to us with respect to this matter?
I would, Mr. Chairman. I appreciate the opportunity. I know there are a number of matters here before the board or the commission on this issue. I would first like to say at the outset that the board regrets that what should otherwise have been a straightforward and simple CPCN application has turned into the contentious and complicated matter that is before the board here today. That was certainly not, or the commission here today, that was certainly not the board's intention when it filed its application for CPCN, and it was certainly not the board's expectation when it discussed this matter and provision of utility services for these properties with the city over a year ago. Back in May of 2018, the board has been in discussions with the city as far as providing utility service for these properties. It's based on those discussions that the board engaged the property owners and set in motion the application that you have before you here this afternoon. In fact, back in March was when the board first reached out and engaged the PSC related to this matter. And there are emails and calls that follow suit with that. The reason why that's important is because those steps were taken well before the present lawsuit between the city and the Board of Public Works boiled into the litigation that we have before us here today. So I can say with confidence that the city's assertion in its motion to dismiss that this is nothing but a ploy by the Board of Public Works to bolster or embolden its litigation position is demonstrably false. It's not true. The board's intentions in seeking this CPCN are simple and they're transparent. There are two property owners that have requested water service from the Board of Public Works. The Board of Public Works has infrastructure in place and available to provide water service. It is ready, willing, and able to provide safe, reliable, and efficient water service to the requesting entities. And but for the city's objection, this matter would have been on the Commission's consent agenda, and it would have been approved as a matter of course. The only reason why you have many attorneys and many motions in front of you here this afternoon is because the city has filed a motion to dismiss, first petition to intervene and then the motion to dismiss. And so the fundamental question is why? Why is the city objecting to this matter? If you look through the city's motion, I think the city has presented its position pretty clear, that the city's view is a property owner, if they want utility service, must first enter into a pre-annexation agreement with the city. And so in other words, enter into a pre-annexation agreement and obtain water service, or don't enter into a pre-annexation agreement and go without water service. That's the city's position. From the board's position, Delaware law is clear that that's not a basis upon which to hold up a CPCN application. Suppose, for example, that the city passed a resolution, that the city passed a local regulation that required any property owner contiguous to the city, adjacent to the city limits, required that property owner to sign a pre-annexation agreement before obtaining any utilities from any providers. The city, if Tidewater, for example, under that example, had submitted for a CPCN, the city filed a petition to intervene and then filed a motion to dismiss on the basis that the CPCN should not be granted to Tidewater because the property owner didn't sign pre-annexation agreement. The question before the PSC is whether it should withhold or prohibit Tidewater from obtaining a CPCN purely on the basis of the city's interest in enforcing a local regulation that it has adopted. Again, I submit and I direct the Commission to Title 26, Section 203C, and this Commission's prior findings relative to that section, which includes very clear statutory deadlines, very clear provisions that the CPCN law and this Commission's prior determinations, interpretation of that law, is that the CPCN provisions are rooted in a public policy that favor the expeditious expansion of water service to Delawareans. In other words, the General Assembly intends that the Commission approve any CPCN application that meets the statutory criteria. There is no question here that we meet, that this application satisfies the statutory criteria. And again, but for the city's interest in enforcing its local regulation, this CPCN would be granted. So essentially we are faced with a situation where the Commission is being asked to play a role in enforcing local regulations. Again, the BPW's position is that that is not appropriate. The policy in Title 26 is clear that if you meet the statutory requirements, a CPCN shall be issued expeditiously. And the BPW's position is that both CPCNs should be issued for both property owners. I understand that since the application has been filed, the medical center parcel, one of the parcels, has signed a pre-annexation agreement, and the city does not object to providing water service to that parcel. Certainly, the board supports that and does not object to the Commission granting a CPCN for that parcel. The board would further request that, for the reasons I just outlined, the PSC also grant the CPCN for the balance of the property. Again, given the statutory deadline and the PSC's interest in public policy of providing CPCNs. But in the alternative, the board is aware that the city has filed, but a week ago, a motion to dismiss. And so in the alternative, the board would request that the PSC exercise its option to extend the 90-day statutory deadline an additional 30 days to allow the BPW a full and fair opportunity to present its response to the city's motion to dismiss. And Mr. Chairman, I appreciate your time and the time of the commission.
Thank you very much. Who's next? Mr. McGonigal?
Mr. Chairman, members of the commission, good afternoon. Tom McGonigal with Drinker Biddle representing the city of Lewis. I want to thank you for your consideration of this issue today. It is a very important issue to the city. Issues of annexation, managing development and growth, being fair to the city's taxpayers, and the financial stability of the city are critical. One of the reasons why we have with us here today the mayor and members of city council and the city's town manager. What the city is really asking for today from the commission is to maintain the status quo. To maintain the status quo while the Superior Court decides some legal issues between the city and BPW. Staff's proposed order does that, and we support it. To be clear, the city is not trying to put the commission in the middle of this dispute. We're actually seeking to do the opposite. The reality is the city would rather not be in this fight with its utility. It's expensive, it's divisive. But the problem is BPW has filed a lawsuit against the city in Superior Court. BPW has filed this application with the commission without notice to the city in advance. And the application is being filed with the presumption that they're going to grant a waiver to the pre-annexation requirement. So when you couple the litigation with what they're seeking in this application, it has the potential to challenge or to change the status quo dramatically. And so that really has left the city with little choice in terms of litigating these issues in Superior Court. So the city needs to respond in Superior Court, and we have. What is not necessary is to have litigation on two fronts. This process, getting these legal issues resolved, leads to the same place, the Superior Court. There's no good reason to have collateral proceedings here. There's no reason why this application cannot wait. We have a briefing schedule. Opening briefs were filed yesterday. The court will have an opportunity to decide these legal issues in pretty short order. But what's important to keep in mind is this pre-annexation policy that's at issue here has been in place for many, many years. It was endorsed, supported, followed by the BPW for many years. In fact, I think there's still a resolution on the books with BPW that says it's in the best interest of BPW and its ratepayers. The city has a law on the books requiring pre-annexation agreements, and has passed a resolution as well. This is the status quo. This is not Tidewater. It's a completely different situation. And any landowner seeking to connect up to BPW would know about this status quo. It's been in place for a very long time. And so what's happening here is BPW is seeking to unwind this status quo by its filing in Superior Court coupled with this filing here. So they're seeking in Superior Court to have the court determine that they're separate and independent from the city. That's one of the big legal issues that's in play in the Superior Court. And in front of the commission, they're seeking a CPCN with the intent, and they've expressed this in their pleadings, to grant a waiver. At the same time, in their briefing yesterday, they argued that the granting of a waiver itself makes it unenforceable. So these issues between what's happening here in front of the commission and what's happening in the Superior Court are very much interrelated. If the city's view of the law is correct, then BPW is a subservient agent of the city, and the city can direct its activities. If BPW's view of the law is correct, they can move forward with this landowner as they wish. But again, we're not asking the commission to decide those legal issues. We are seeking, as staff has suggested, to stay this application so the Superior Court has a chance to look at these issues, resolve them, and we think that's the most efficient way to proceed. One last point on this issue of the sort of, I call it the shell issue argument with respect to the statute that was referenced. 26 Delaware Code, Section 23CH1 is the reference, and it talks about the commission shall act on the application within 90 days. It doesn't say what that action shall be. I think that's up to the commission to decide. It seems to me that a decision by the commission that the application can proceed in part with respect to Mr. Nutter's client's property, the Cape Henlopen Health Center, and a decision to stay the remaining application constitutes action under the statute. And I think that's essentially staff's position. If the commission concludes that it is bound to either grant or deny, that's why we filed a motion to dismiss. We don't think it's the most efficient way to proceed. We're not necessarily looking for BPW to start over if they win in Superior Court. But if the commission believes its hands are tied under the statute, we are seeking for denial, and that's why we filed that motion. So, in closing, the city does not really want to be in this fight, but we don't feel there's much choice because the consequences of these decisions have significant implications going forward. And we're simply asking this commission to preserve the status quo until we get a decision from the court, and then we can move forward. Thank you.
Thank you, Mr. McGonigal. Mr. Nutter? Oh, I'm sorry, Connie?
Your Honor, I believe that the commission needs to vote on the order to allow the intervention of these parties first. That's order 9476.
There was, if I recall correctly, there's no opposition to the motions,
Correct.
so we can take it up now, I guess, if you want, if that would be
Please.
better. Commissioners, do you have any questions about the motions to intervene?
Mr. Chair, I move that the commission adopt order number 9476 as submitted.
Second the motion?
Any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? Motion carries. Mr. Nutter.
Good afternoon, Mr. Chairman, members of the commission. James Nutter with Parkowski, Gerken, Swayze on behalf of the intervener Cape Henlopen Medical Center, LLC. Here today is Megan and Mike Glick with Cape Henlopen Medical Center. Ms. Glick is the co-managing member of the LLC. And Cape Henlopen Medical Center owns the smaller parcel, Lot 1 of the Mitchell Farm. It was subdivided earlier in the development process, and Cape Henlopen Medical Center is being constructed into pre-leased medical office space for a local orthopedics practice. And they need water. I attached a picture of the exterior shell. It is substantially completed, and they need to begin the interior fit-out in a timely manner to enable the medical practice, some of the doctors of whom are members of Cape Henlopen Medical Center, to relocate when their existing lease expires in December and cannot be renewed. And so recently there was a close-in inspection with a plumber who said, we're not going to be doing any more water inspections until you have water service. So they need to be approved as expeditiously as possible in order to complete their construction schedule on the time frame needed for the medical practice. And the Cape Henlopen Medical Center has no interest in being in between the City of Lewis and its Board of Public Works with respect to whether or not there's the legal authority to enforce a pre-annexation agreement or not. The BPW did grant a waiver of the requirement to this small parcel. That was before Cape Henlopen Medical Center purchased Lot 1. And since purchasing Lot 1 and becoming aware that this dispute was pending before the city and its BPW, they did execute a pre-annexation agreement with the city, agreeing that if the parcel does become contiguous, it will be annexed into the city. So at present, there's no dispute as to whether or not the BPW has the legal right to serve. It is a completed application with respect to the Cape Henlopen Medical Center parcel. We did ask the commission consider and make a separate finding as to the Lot 1 parcel and enter a separate order as to the Lot 1 parcel, so that if the matter is continued another 30 days here at the commission or ultimately appealed to the Superior Court by the party, either the city or the BPW that feels the commission may have erred, that the order and the right to receive water service from the BPW is not interfered with or placed in jeopardy. We do support the staff's memorandum. We do support both of the proposed orders. I do note that the order that the commission did approve, 9476, does say that the commission, even with respect to the intervention order, does say that the commission is going to act and grant the CPCN solely as to the Cape Henlopen Medical Center parcel. I don't know if that was the commission's intention when it adopted the intervention order, but nonetheless, both of the orders are essentially the same, and we ask and support both of them, including the staff's position that regardless of what happens with the bigger, larger parcel, Cape Henlopen Medical Center should be approved to receive water from the BPW today. I'm happy to answer any further questions.
Thank you, Mr. Nutter.
Good afternoon. For the record, my name is David Hutt. I'm an attorney with the law firm of Morris James, representing another one of the interveners, the Mitchell Family LLC, which is the owner of, I'll just use the last few digits of the tax parcel system, parcel 37, situated along Kings Highway and Gills Neck Road. I'd like to thank the chairman and the members of the commission for affording me and my client the opportunity to make some comments here and to file the petition to intervene that was filed. I wanted to begin this afternoon by correcting the record, which I think needs to be corrected with respect to two matters. As part of its material, as was just referenced a moment ago by Mr. Nutter, the staff has a memorandum that's dated September 30th. At the top of the third page of that memorandum, there is a statement that parcel 37 is currently part of the Superior Court actions, and that staff's recommendation is that the CPCN petition for parcel 37 be revisited after the Superior Court action is complete. Again, this is, in my opinion, wrong on two matters. One is the legal matter, and Mr. Hoffman and Mr. McGonigal already addressed that, so I don't want to go into details on that, and that's with respect to that this commission by statute has to act on an application within 90 days, and then the statute does afford, when good cause, and only when good cause is shown, a 30-day extension period. The more significant, I think, incorrect statement within that is that the Mitchell Family LLC is part of the Superior Court action. That is simply incorrect. The Mitchell family is not part of the Superior Court action, and I think that's one thing that you've heard from now 4 straight attorneys, is for some reason none of them want to be part of this dispute that's going on in court. But similar to that, the Mitchell family is not part of that lawsuit. They are not one of the parties to that lawsuit and are not part of the pleadings, nor do they intend to embroil themselves in the lawsuit that's pending in Superior Court between the Board of Public Works and the City of Lewis. As I was thinking about this, and some people that are here have heard me use this before, but so it won't be new to them, but the most apt analogy for this in my mind is that it's sort of like a divorce, and my client, the Mitchell Family LLC, is one of the children that hopes that business returns to normal between their parents in that regard, and that's the city and the Board of Public Works. My client recognizes that it is not the only party who's been awkwardly placed in the middle of this dispute. I'm sitting next to an attorney for one of the other siblings in this divorce that's been placed in this same awkward situation. And I will express that my client is certainly frustrated by the feud between the city and the Board of Public Works and its impact on the confirmation of this basic utility service to its property. I think that frustration is magnified in this matter because the request for the CPN to my client seems so basic and simple. The Board of Public Works is already committed to, I believe, and that is the first 200 feet, but I could be wrong about the number of feet, but for electric service to my client's property situated along Kings Highway. The property clearly lies within BPW's service area. There is also express authority within all of the documents for the Board of Public Works to supply utilities within 2 miles of the municipal limits for the city. And those are the types of conversations and thoughts that my client had. Mr. Hoffman referenced those conversations that date back, I think, even before the May 2018 conversation that he alluded to in his opening comments. But it made it seem to my client as though, I guess the colloquial expression is it'd be a no-brainer for my client to sign a petition as part of that process for the Board of Public Works to seek a CPCN for water for its property. Of course, my client could not have anticipated that a power struggle would break out between the City of Lewis and the Board of Public Works. This afternoon, my client's request is that the client grant the CPCN petition that was applied for by both parcels, both 37.01, which is Lot 1, the parcel that was just described by Mr. Nutter on behalf of Cape Henlopen Medical Center, as well as parcel 37, which is the parcel owned by the Mitchell Family LLC. Having said that, my client is fully in support of, I'll go back to my analogy, its sibling in this matter, and if the commission so desires, my client entirely supports separating the two applications or petitions from each other so that water can be provided to parcel 1 to the Cape Henlopen Medical Center building. As you heard from Mr. Nutter a moment ago, that building is ready for water. My client executed a development agreement. The infrastructure is in the ground. To my layman's terms of a utility, I think all that needs to happen is a valve needs to be turned, and that building will have water. And my client fully supports that building, that CPCN petition being granted for that building. In addition, certainly my client would ask that the CPCN petition be granted for its parcel, parcel 37, as all of the statutory and regulatory requirements have been met, and frankly, to my client's way of thinking, it just makes basic common sense for the petition to be granted. As I'm sure all the co-counsel here is certainly ready, willing, and able to answer any questions that any of the members of the commission may have.
Thank you, Mr. Hutt.
Thank you, Mr. Chairman. Just a point of clarification before we move on to the next testimony. I'm envisioning there are two parcels. My question is, does the water need to move through the Mitchell parcel before it gets to the hospital parcel?
Good afternoon, Mr. Chairman, members of the commission. Michael Hoffman again for the record. With me here today, I have Darren Gordon, the general manager of the Board of Public Works. I believe with the commission's indulgence, he can speak to that factual question.
The answer is no. Thank you.
Thank you.
Thank you,
Mr. Walsh?
Thank you, Chairman, members of the commission. I will try to address each council's statement. I should start just saying that staff supports entry of Order 9475, which I believe does what Cape Henlopen Medical Center is requesting. They have submitted a pre-annexation agreement. They do need the water, and this order approves the CPCN as to that lot, which is 3701. We do not believe that the larger lot, 3700, the CPCN should not be granted as to that, and that is, as I believe Mr. McGonigal mentioned, the status quo. What is important here is the ordering paragraph that is in all CPCN orders, best of my knowledge, which states that the applicant shall comply with any and all federal, state, county, and local statutes, ordinances, orders, regulations, rules, and permit conditions that are applicable or may become applicable. That is the issue. They have already expressed to the Superior Court and to this commission that you grant the CPCN as to that parcel, your order in paragraph number 3 will not be adhered to, and that is problematic. And what will be applicable, well, what is applicable right now, based on their expression, they plan to abandon it or disregard it. What may become applicable hereafter, based upon the Superior Court's decision, may change that. And I think it only makes sense, in deference to the Superior Court and the parties having filed briefs, and of course the Superior Court having the jurisdiction over the declaratory judgment in this case, that this matter be stayed the additional time allowed under 203. I believe it is correct that staying it is acting on it. This is not like a 215 application where after the expiration of 30 days becomes operable, by operation of law, becomes effective. 203 does not say that. I think this is the right thing to do. As for good cause shown, I mentioned it already. This action is pending in Superior Court. There will be a court decision, and it will clarify what statutes, local ordinances are applicable or may become applicable. As Mr. Hoffman's representation, that but for the city's motion to dismiss, this would have been on the consent agenda. I just respectfully add that that is not the case from staff's point of view. This application was filed. A week later, declaratory judgment was filed. I don't believe Superior Court knew of the CPCN application, and we were not aware of the declaratory judgment action being filed until later. The Board of Public Works did not mention that to us. So if there is transparency here, that component of transparency was missed, and it's a vital component. I believe there is some proper judicial deference that should lie in this matter to retain that status quo. For all those reasons, staff would support entry of Order 9475, which would grant the CPCN solely as to the one parcel, Mr. Nutter's client, which is Lot 1, 3701, and not grant the CPCN as to the second parcel until we know what the Superior Court is going to do, or until we find out what it does. That's going to be vitally important. It avoids having a dual track. One of the parties mentioned, I believe it was Mr. McGonigal, the dual tracks, and the awkward situation of having factual record here, factual record there, and if this were to be appealed, Superior Court, that would be an unusual situation to have the Superior Court then considering an application, a CPCN application, where it may still be deciding the issue on the declaratory judgment, and perhaps that could be appealed to the Supreme Court, and you would have these dual tracks. I don't know if they would be in parallel, but it seems very unusual legal scenario for this commission to embrace, where the more sensible solution, I believe, is to issue this order as to one, return to the other after the Superior Court action, and I don't believe that would prejudice any of the parties. It would certainly be helpful to Mr. Nutter, and it would allow this to be properly adjudicated, and this commission would have direction as to that local ordinance.
Thank you, Mr. Walsh.
Mr. Chairman, excuse me. Before you act on the order before you, 9475, I think we should have a 5-minute recess so that I can confer with the attorneys. There's some text that's awkward, and I think somehow it slipped in, and I really think we should look at it before you act on it, sir.
Okay, we're not about ready to take any
Okay, so-
immediate action,
all right.
but we do have one more person. He's shaking his head, so I guess he's one person who's not going to get in the middle.
Mr. Chairman, I don't believe that we had intervened in this docket, so I
Oh,
won't speak any further.
Mr. Hoffman?
Thank you, Mr. Chairman. I just very briefly and just for the record and a couple quick points. Again, as to the timing of the application, again, I can be absolutely clear and absolutely certain that the litigation did not impact the filing of this CPCN request. That had been set in motion well before. So with all due respect to Mr. Walsh, the timing is unrelated as to the two. But I do think it's important to highlight the status quo, because we've heard a lot about the status quo. The status quo for decades has been that the board apply for CPCNs, and as it meets the statutory requirement, those CPCNs are granted. Again, this CPCN request is being presented at the request of two property owners, where infrastructure is in place, it's available, the board is able to provide the utility service. Mr. Walsh touched upon, I think, an important point, and that is CPCNs that are granted by this commission are subject to local regulations. If the question is the enforcement and application of a local regulation, then that is not a matter before the PSC. There are other venues available to the city to enforce local regulations. If the city believes that the board is not going to continue the regulation, or there's some basis for that, then that is a separate matter. The question for the PSC, as this commission has previously held in for example, a Tidewater matter, I don't have the docket reference on the top of my head, but the point is that the intent of the General Assembly in Section 203C is to expeditiously issue CPCNs where the statutory criteria has been met. That statutory criteria has been met. Nobody in front of the commission today is objecting or contending that the statutory criteria has not been met. The sole question is whether in granting the CPCN, is there going to be a question on local regulation and the enforceability of local regulation? If that's the sole question, again, the CPCN is granted subject to local regulation, and it's up to the parties to enforce that. If I can offer an example, let's say the property owner believed that it should install a 3/4 of an inch main, and the board or city believed that it should install a 1-inch main. If that the PSC wouldn't hold up the CPCN while the parties determined which main size to install. So the city would say, if you met the statutory criteria, CPCN would issue. It's up to you all to enforce the local regulation. I think that's what is at the heart of this matter here today. And what the board is asking, and what the commission's prior decisions support, is that where the statutory criteria has been met, it's asking the commission to grant the CPCN, and to the extent there are questions on the local regulation, allow those to play out in due course. The one final point I'd mention is to the local regulation. The question as to the enforceability of the pre-annexation agreement is actually a good point that Mr. Hutt had raised. A portion of the property before this commission here today is already within the board's electric service area. The board already has an obligation to serve. What the city is saying is sign a pre-annexation agreement and get electric, or don't sign it and go without electric. No other provider can provide electric. That is not a tenable situation. That is not in the interest of public policy. That is a discriminatory application, which is why the board is challenging the application of the pre-annexation condition. So it is not a slam dunk that this local regulation will be upheld as enforceable, and we submit it's not a proper matter for the PSC. And to grind the PSC's operation and business to a halt is actually to go against the status quo, which is otherwise to grant CPCNs where the statutory criteria has been met.
Thank you, Mr. Huffman. A question for you.
Sure.
Excuse me. I've been sitting here for almost 15 years, and I've never seen a situation like this. You indicate there's previous cases. I can't recall one that involves a Superior Court case pending at the same time a CPCN has been applied for.
Certainly, Mr. Chairman. The case I was referencing, and I would be happy to provide the docket reference post-recess. But the intent of the provision, and you're correct, I'm not personally aware of a situation where there is pending litigation, but the intent of Section 203C is to expeditiously issue CPCNs that meet the criteria. My point is that if the sole contention here, if the sole consideration is the enforceability of a local regulation, then that is a matter for the courts. For example, if the commission were to issue a CPCN, it would be subject to the local regulation. If the city believed that that should be enforceable, or the board would take some steps not to enforce that local regulation, the city could file for an injunction. The city has remedies to enforce local regulations. Remedies, the city's applicants, parties don't, and actually to your point, Mr. Chairman, I'm sure the commission has not had an application in the past where parties coming before it to enforce a local regulation. They don't come to the PSC to enforce local regulations. That's for courts out of the PSC. The question before the I apologize, Mr. Chairman.
No. Go ahead, finish up, please.
Thank you. The question for the PSC is, are the statutory requirements met? And here they very clearly are.
Another question for you. What sort of harm would your client suffer if the commission were to adopt the order as proposed by staff?
I think there are two points. I think the first point, the first concern, is the impact on the statutory application and the commission's ability for a permanent stay. Again, to the extent that the commission is inclined to exercise the 30-day extension, certainly we would take that opportunity to prevent a more full and fair briefing in response to the city's motion, as opposed to just the oral presentation here today. But the second point, again, it kind of comes to the core purpose of the PSC. That is that you hold this CPCN in limbo going forward. I think more specifically, Mr. Chairman, your question and concern is more appropriately directed to the property owner impacted. For the board's position, again, our point and our position is that we are ready, willing, and able to serve. We're applying for the ability to do so. So from our perspective, it's just about maintaining the status quo of being able to acquire CPCNs and provide service. As far as the specific harm, again, that would be more aptly directed to the property owner.
Mr. Chairman, may I, in response to your Honor's question, I think in not answering it, Mr. Hoffman answered it. He cannot identify any harm. He is referencing the Public Service Commission's abilities and handling of dockets and the developers. But it's the BPW that brought the CPCN application, and Mr. Hoffman did not state any harm as to BPW. And I'd made a note here about the status quo, but Chairman, you hit that point already. He mentioned that this has been the status quo for years, and nobody seems to be aware of any CPCN application filed on day one, and then a week later, a declaratory judgment filed in Superior Court, and the left and right hand aren't relaying to anybody else involved that they exist. And I think that is an issue. That's not status quo. And the final point, you mentioned, Mr. Hoffman mentioned that this was a discriminatory practice, this pre-annexation agreement. That is before the Superior Court. And I respectfully submit that this commission is better suited to allow the Superior Court to make that decision, particularly where, under the statute, we have good cause to extend the time. And if BPW wants to formally respond to the city's motion to dismiss, it certainly can do so. But the good cause does exist. And in the interim, perhaps we'll get an order, decision from the Superior Court. And this will be a moot point, and we can forthwith get the CPCN on the docket. If those matters are closed, perhaps it will be on the consent agenda.
Mr. McGonigal?
Just one point, please, Mr. Chairman. So when the commission issues these orders, as Mr. Walsh has indicated, there's language that says compliance with local ordinance is required. Presumably, that is the order that would be issued here. In this situation, we have a local ordinance that's been passed by the city of Lewis. We don't have to guess what BPW's position is. They filed a verified complaint indicating that they're going to completely abandon that policy. So we know sitting here today, based on their own verified complaint, that they plan not to follow that ordinance, which essentially means they're not going to follow the commission's order if you grant it. Now, they're going to argue that the ordinance isn't applicable to them, and that's all the stuff that we're arguing about in the Superior Court. But that's the situation we're in right here, and we don't have to guess at it. They filed a verified complaint. They made it crystal clear what their intentions are. There's no mystery here. They're not going to follow the ordinance as the CPCN moves forward.
And Mr. Chairman, just very briefly,
Okay, go ahead, Mr. Hoffman.
and again, I just want to clarify, and I think to Mr. Walsh's point, again, the CPCN had been in motion and had been filed separate from the litigation. And I think that actually highlights exactly the board's mindset in this matter, that they are two separate matters, that a request for utility service versus the enforcement of a local regulation. And that at its core is really what is before the PSC. That is whether the PSC should stand by and get and have the process ground to a halt for the enforcement of a local regulation. And so again, in fair, I can unequivocally state there was nothing nefarious. There was no intent. There was no intent not to be transparent. Again, you have two very separate things, and that played out in the timing.
I understand from, Mr. Walsh, I understand from Dr. Brewer that he has requested some couple minutes of consultation with you about an issue.
That's correct.
And,
Chairman.
and it's a little bit unusual, but, and I see all these people here from Lewis, and I hesitate to do this, but I think we've had enough argument. Mr. O'Brien's our lawyer, so he wants to get a word in.
I was just going to clarify that point for the commission, that I'm commission counsel on this matter. Mr. Walsh is staff counsel on the matter. So if you have questions for staff's position, that would go to Mr. Walsh. If you just have general legal questions outside of what's been presented, or even including what's been presented, you can come to me on it.
Dr. Brewer, how much time do you need to talk with Mr. Walsh?
Actually, I would need both of them, 5 minutes.
Well, I can clarify right now.
No, I think we should talk about it back before we clarify on the rest.
Mr. Chair, I have a thought. Is it reasonable that you gentlemen exit the room and leave the rest of us
That's where
here?
I'm going.
Okay.
We're leaving the room.
Well, that doesn't resolve the issue as far as I'm concerned. I mean, obviously you should leave the room, but what I want to do is, I don't want these people, Mr. Wilkerson's here finally, Wilkerson Water Company. I don't want him sitting in the back of the room much longer. And the people here from Lewis have got to be here till we conclude this matter. So we're going to take a 5-minute recess from this pending issue, and we're going to go on with the rest of the agenda, get as much as we can done. And when Dr. Brewer and Mr. Walsh return, we'll go back into session and we'll resolve the Lewis matter.
Thank you.
So if we could, we're going to adjourn this matter for a few minutes, and we're going to take number 2, which is the matter of the joint application of Tidewater Utilities and Wilkerson and Sons for approval of the sale and transfer of the Wilkerson Water Company.
Chairman Winslow, I'm sorry to throw a wrench in this. That is my matter as well. Number 3, Mr. Geddes is handling, if that would be number 3 on the regular agenda, docket 190604.
What is your position on number 2? Is the
Staff's
position to approve the order?
position is to approve the order as submitted.
Do you think it'd be safe for you to take off now?
I think it would be, and Ms. Striggins, I believe, is here in the event there are
Yes, maybe Lisa, if you come forward, please.
any questions.
Gentlemen, ladies, have a seat, please.
I'm happy to say that on the record on behalf of Mr. Walsh at the appropriate time.
Good afternoon. We have, I guess we're got Tidewater's here. Mr. Nutter?
Good afternoon, Mr. Chairman, members of the commission. James Nutter with Parkowski, Gherkin, Swayze on behalf of Tidewater. Tidewater is a joint applicant in this matter, along with Mr. Wilkerson, and before the commission is a joint application of Tidewater and J.H. Wilkerson and Son for approval to consummate an asset purchase transaction whereby Tidewater will acquire the assets, including the water service rights of J.H. Wilkerson and Sons regulated water utility divisions. They are Wilkerson Water and Broad Kilton Beach Water Company. Included with the application are the asset purchase agreement entered into by the joint applicants, as well as Mr. Wilkerson's personal letter to his customers notifying them of the pending transaction and explaining that after 57 years of operation by his family, it's time to pass the baton to Tidewater, a very well-established and well-managed Delaware utility with the operational expertise and the organizational scale to assure that Mr. Wilkerson's customers continue receiving safe, adequate, and reliable water service. The transaction is structured so that essentially all aspects of Wilkerson's 2 water utility divisions are being transferred to Tidewater. Wilkerson Water serves approximately 523 customers through 7 community water systems. One of those is in Kent County, and the other 6 are in Sussex County. Broadkill Beach serves approximately a similar number, 508 customers approximately in Broadkill Beach community along the Delaware Bay in Sussex County. In total, there are about 1,500 parcels being transferred, certificated parcels, and that's because there's some vacant lots and some lots that aren't currently receiving service. Wilkerson and Broadkill customers receive water pursuant to flat rates that are set by the commission. The rates for Broadkill service territory were last set by the commission in 2008. And at that time, there was a metering study done to see what the cost would be to install individual meters for each property. And Wilkerson Water's rates were last set in 2015. And then perhaps a bit of foreshadowing in that settlement agreement. The commission approved a settlement agreement setting the rates, but also asked Mr. Wilkerson to file with the commission a succession plan. So the transaction today, it sounds like, is part of Mr. Wilkerson's succession plan. The proposed transaction before you is consistent with the law and for a public purpose and in the public interest. From a customer standpoint, the transaction will be seamless. Water service will be uninterrupted, and no changes to the rates and terms of service are being requested at this time. Tidewater anticipates that if approval is granted, they will complete the application within 30 to 45 days. Customers will receive Mr. Wilkerson's personal letter after the commission, if the commission approves the order today, and then after closing, Tidewater anticipates sending its own welcoming letter, if you will, explaining the service that they will now receive from Tidewater and the terms and conditions under which that service will be provided. Tidewater has reviewed staff's memorandum and proposed order number 9474. We believe each accurately set forth the transaction and the public purpose and public interest for which the transaction is being entered. We respectfully request the commission enter 9474. Mr. O'Connor, President of Tidewater, is here to answer any questions, as is Mr. Wilkerson, should the commission have them.
Thank you, Mr. Nutter. Mr. Walsh?
Chairman and Commissioners, for the reasons stated in staff's memorandum, and I know Mr. Nutter accurately presented those to the Commission, staff supports entry of order number 9474, this docket.
Thank you, Mr. Walsh. Mr. Slater?
The DPA also supports the form of order. Thank you.
Thank you. Commissioners, any questions of Mr. Nutter or anybody in the room?
One clarifying question. Water has two sides of the ledger. Is this drinking water and sewage treatment, or?
Good afternoon. I'm Bruce O'Connor, President of Tidewater Utilities. This involves the ingestion of water only.
Chair, I move that the commission adopt order number 9474 submitted.
I seconded.
Any discussion? Hearing none, all in favor signify by saying aye. Any opposed? Any abstentions? The motion carries. Congratulations, Mr. Wilkerson. Come back and visit us again.
Thank you.
Thank you.
If we could go back to the Lewis matter, please. Got Mr. Huffman and Mr. McGonigal. Okay, we've concluded the argument. Commissioners, any questions? Mr. O'Brien?
Thank you, Chairman. Again, I'm Commission Counsel on this matter. I just want to clarify a discrepancy between the agenda and the order numbers. You do have an order before you, 9475, which is actually identical to 9476. The agenda has it as two different orders, one for the intervention petitions and one for the uncontested parcel owned by Mr. Nutter's client. But the way it was written up for the commission was that there'd be one order granting the uncontested interventions and granting the uncontested parcel. So we can strike one of those two orders, and you can vote on the other order in full now. You've already voted on the interventions and granted them from a substantive viewpoint. But now you can vote on the order itself, which grants the interventions and the uncontested parcel. And we can call that 9475 and just simply strike 9476.
If I understood what you said, we voted on 9476, which comprises an authorization for the intervention and an authorization for service to one of the parcels already. Is that correct?
That's correct. It's just, on the record, you can vote again since it was only presented as a order that granted the interventions, when actually it's an order that grants the uncontested parcel also.
Can we motion the service to the separate parcel as the same order number 9476?
Yes.
To embrace that element?
Yes, and,
Okay.
right, you can just call it 9476. I had said 9475, but I didn't realize you had mentioned the order in the last one being 9476. So I would reaffirm your vote on 9476 with full understanding that it is also granting the CPCN for the uncontested parcel owned by the Cape Henlopen Medical Center.
But not for the other parcel.
Right, there was no order in front of you for that parcel.
Just make sure.
Well, I live about a mile away from that parcel, and I don't think I want to be picketed by the owners of that parcel, so I think I'm going to support the CPCN for that parcel. Mr. Huffman, I appreciate your arguments, but I don't see any harm or injury can occur to your client if we were to approve the other parcel and, you know, give it extra time for the motion to dismiss and put off the other matter for a while. The only problem I have is that I'm sort of very conscious of the fact that it costs money to do these things. And so I think that, the way I'm thinking is probably the least financially hit, so to speak, on the parties. But I really don't know how long it's going to take Superior Court to resolve this issue. So that presents perhaps some problem. Mr. O'Brien?
Right, so you do have on the record a request from BPW for an additional 30 days, as is allowed by the statute for good cause shown. When it's in the public interest, you can add 30 days to the 90-day deadline for action on CPCNs. Had Mr. Hoffman agreed to present his argument orally on the motion to dismiss today and rest on that argument, you could have then, of course, taken up the motion to dismiss from the city and given an answer on that. But you do have a request that he be allowed an opportunity to make a written response, since the motion did come in writing. Correct me if I'm wrong on that, Mr. Hoffman.
That's correct. Thank you.
And it does sound like staff has supported that part of the request, which is an additional 30 days on the statutory 90-day deadline. And I say statutory, but those 30 days are statutory also. Those are allowed by statute.
Clarification, does the 30-day extension have to comprise the entire scope of the current CPCN? Or can we adopt this element of order number 9476 to allow one parcel and then allow the 30-day extension on the rest?
Commissioner Gray, yes, you can do that. There are no objections to that here today. Since that CPCN is not subject to the Superior Court action, at least that parcel is not subject to it because there has been a pre-annexation agreement signed and the parties do not object to that portion of the CPCN request. You can certainly grant that parcel, but defer on the other one until BPW has a chance to provide written response to the motion to dismiss and then rule on the motion to dismiss.
So you want to make a motion, Commissioner Gray? Or I'd be happy to do it.
So I will move that we reaffirm the adoption of order number 9476 to allow service to one parcel as applied, and that we defer or allow the 30-day extension for response on the motion to dismiss.
I second it.
Okay, we got 2 seconds.
Is there any discussion on the motion? Yeah, Mr. Hoffman, I really do think you make a lot of good points. But the problem is that, as far as I can see, there's not going to be any harm to your client. And this is a situation where the commission is mindful that the next court up is the Superior Court, and we don't really want to get entangled in their business, and we don't want to affect the rights of any of the parties by making a decision that might adversely impact upon somebody. So I will be supporting the motion as stated, and I wish you all well, because it'd be a good thing if you can resolve the issue between both of you. And so any more discussion? All those in favor of the motion signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you very much, and best wishes to you all.
Thank you.
Thank you.
Okay, the very, okay, the last matter is in the matter of the tariff filing by Chesapeake Utilities Corporation for a new rate schedule MVFF called Town of Millville Franchise Fee Rider. We have Ms. Cosell.
Ms. Kozel,
Kozel, excuse me,
we're close.
Kozel.
Good afternoon, and thank you, Chairman and Commissioners. Marie Kozel on behalf of Chesapeake Utilities Corporation. Chesapeake filed an application on September 18th, 2019, seeking approval of a new rate schedule for the Town of Millville Franchise Fee Rider, rate schedule MVFF. The proposed surcharge of 1 cent per CCF of delivered gas is meant to mirror the volumetric franchise fee imposed upon the company by the town of Millville under the franchise agreement, which was adopted on September 10th, 2019. In addition, the company is requesting that the commission waive the 60-day notice requirement for a rate change and schedule this matter at a regularly scheduled commission meeting to consider the tariff changes, implementing the surcharge to be effective November 5th, 2019. In front of you is proposed order number 9479, which will open the docket for this proceeding. Chesapeake respectfully requests the commission enter order 9479, and thank you.
Thank you. Ms. Cozell.
Like Howard.
No, it's Kozel, not Cosell.
Well, that's the way he.
Mr. Walsh.
No, I believe that, I'm allegedly supposed to represent the staff with regard to this order. I'm happy to say it does not involve the CPCN, and I agree with everything that Ms. Kozel said in support of the order, and recommend its favorable consideration. It opens up the docket to look at the term. Thank you.
Mr. Slater.
Likewise, I have nothing to add, Mr. Chair.
Ms. Kozel did such a good job. Commissioners,
you.
any questions?
Move we adopt order number 9479 as presented.
I second it.
Any discussion? Commissioner Gray?
No?
No? All those, we had a first and second, right?
Yeah.
All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries.
Thank you very much.
Thank you, Ms. Cosell. Kosel?
No.
Representative of Chesapeake.
We have nothing on the hearing schedule. Is there anyone here from the public that would like to make some public comment? And we don't have our DENREC friends here today. We haven't had the DENREC. Is Tom still works for DENREC, doesn't he? Yeah. Okay, well, we miss him. Let's see, director's comments, Dr. Brewer.
Thank you, Mr. Chairman. We need to go into executive session, please.
Do you want to make your other comments first? And then that way
Yeah, the
people
next
will just
commission,
leave?
next commission meeting is on October 22nd, and there are no other comments.
Okay, then what is the reason and purpose for going into executive session?
For advice on litigation, and to seek your approval on that matter.
Okay, we have a motion to go into executive session.
I move that we go into executive session for the reasons stated by Executive Director Barua.
Second.
Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. We're now in executive